Okay, hello everyone. I think that was a request to not go over time, so I'll do my best to not go over time. For those of you who don't know, I'm Ben Hudson and I'm a senior lecturer in law here at the University of Lincoln. Thank you very much for the invitation to be here. It's great to see so many people. So I am the second lawyer of the day. Similar to my colleague Scarlett, I spend most of my time reading books and reading cases, but hoping to find some very interesting things in those. What I'm going to talk about today is my research, which is mostly focused on forced migration and human rights law, with a particular focus on the European Court of Human Rights and the case law before the court. I say forced migration. Typically I've worked in, done research into refugee, asylum and internal displacement, but I'm also now finding myself on the edges of that, where we cross over that sort of false dichotomy between what is forced and what is voluntary, which you'll be able to see from the cases I refer to today. So I'm just going to do a brief overview of this one paper that I wrote that was published last year, titled Migration in the Mediterranean, Exposing the Limits of Vulnerability at the European Court of Human Rights. Now, I probably don't need to go into why this is important in a huge amount of detail. This is just lots of information that I've taken from the UNHCR, the UN Human Rights High Commissioner for Refugees, on the fact that we are obviously in a situation now where forced migration is at some of the highest levels that we've ever seen across the world, and it's one of the biggest global challenges that we're facing, particularly in terms of the Mediterranean and migration across the Mediterranean. I know that it's been in the news, it's been in politics for some years now, but we're now finally getting the cases through, which are very late. Law is always behind the times. We're getting the cases through now so that we're better understanding how the courts and how the law is responding to the greater numbers of people coming across to Europe via the Mediterranean Sea. But it's not just the context that makes this an important paper, I don't think. It's also the concept of vulnerability itself, which is something that is far more common these days in general speech. In common parlance, we hear mentions of vulnerability a lot. It's become a sort of buzzword. But we also see that in the law, in the cases too, and there has been a demonstrable increase in the references to vulnerability by the European Court in particular, but without necessarily any explanation of what vulnerability means to the court, or what it means under the European Convention. So that's one thing that I seek to explore through this work. Just another image, again, I probably don't need to go into why this might be of interest to you. I think it's of interest because some of us have a humanitarian interest in the topic, some of us have political concerns, and we want to know better how we should respond to a situation which is not going to go away anytime soon, and which we have struggled to cope with as an international community. I think it's also important to remember that this can affect any of us at all times. Forced migration is not something that affects just developing nations. It's not a developing nations problem. And if we look at the Refugee Convention, for instance, there's many reasons for why somebody in the UK may feel that they would have to leave their country for one reason or another. It's not intrinsically an issue that affects others, it can affect us too, directly as individuals. So onto the paper. What do I do in the paper? Well, three things primarily. First of all, I did some examination into the literature on vulnerability. In terms of the legal literature, what we see is a lot of criticism, lots of understandable criticism, of a categorical approach to vulnerability. Now, that's essentially a labelling approach, that what we do is we say that groups of people are vulnerable because they belong to a certain group of people. So population groups are vulnerable. So women may be vulnerable, children may be vulnerable, those with HIV may be vulnerable, those from a Roma background may be vulnerable. But when we do that, we do lots of other things as well. We stereotype those individuals, we stigmatise them, we label them as something, and we forget about the individual. So we've seen a lot of criticism of this categorical approach, particularly within the legal literature. The legal literature, the theoretical side, largely focuses on the fact that everyone is vulnerable, that being vulnerable is something inherent to the human condition. That's sort of the way that the theoretical literature has gone. basically saying that there's no point looking at vulnerable groups of people, there's no point in trying to find vulnerability, because actually we are all vulnerable. It's inherent in the human condition to be vulnerable. Now, this literature is interesting, but when I was trying to get to this, get answers to my question of, well, how does the court use the term vulnerable, I didn't find either particularly useful, because you have the categorical approach, which is heavily criticised, but then the universal approach is also criticised, in that if we're all vulnerable, inherently vulnerable, well, why sometimes do we say this person is more vulnerable? How do we recognise and how should the law go about protecting vulnerability if we're all vulnerable? And for that, I actually, because I teach medical law, some of you know about this, but I actually went into the bioethics literature, which I think is quite interesting because it's trying, many of the papers in bioethics are trying to use the term vulnerability in a, we're trying to be able to use it in a way which is actually constructive, to help us to understand why we may see some groups as vulnerable, some individuals as vulnerable, and why not others. So what I drew upon, what I've drawn upon, is some of the bioethics taxonomies that they use. Now, I'm not saying that taxonomies are perfect, because they also themselves categorize and characterize groups. But there's one in particular by Rogers, Mackenzie and Dodd, which I think is quite useful. And that talks about inherent vulnerabilities. That is the fact that we are vulnerable as individuals because we are human. But it also recognizes situational vulnerabilities. So that we're vulnerable because of the situation we find ourselves in. So taking that, I thought I will apply this sort of approach to what we're seeing in the migration-specific cases at the moment before the European Court of Human Rights. Now, the big case where we really saw vulnerability meet with forced migration was the case of MSS in Belgium and Greece. Some of you may be familiar with that. It was an important case because it concerned somebody who had travelled to Europe, travelled to Greece in particular, in search of asylum, and then continued their journey through Europe to Belgium. Belgium then deported them back to Greece under the EU Dublin transfer system, which I won't get into any detail now, but that's perfectly lawful in principle. The case was taken by the applicant, who's an asylum seeker, and the case was to do with the conditions of his detention, that he was in absolutely atrocious situation, an absolutely atrocious situation in Athens airport. I won't go into the details, but you can imagine the situation that he was in. From a vulnerability perspective, what's most interesting was that this was the first time that the court said asylum seekers are vulnerable. And asylum seekers are inherently vulnerable because they are asylum seekers. So for many people, particularly in the asylum advocates, this was a huge win before the European Court of Human Rights. Finally, we're now recognizing that asylum seekers are vulnerable. But if we think about this taxonomy, and if we think about how the court went about labeling this individual as vulnerable, what we see is actually a bit of a concern that rather than focusing on the individual applicant themselves, they actually said that he was vulnerable because he was an asylum seeker. So once again, we see this focus on the categorical, on the labeling approach, which is something that I was concerned about, and something that seems, a concern that seems to have come quite strongly now in the later cases that are coming through the court. So Khalifia and others against Italy, a similar case. Applicants travelling across the Mediterranean Sea. This time, they didn't actively seek asylum. So they weren't asylum seekers as far as the court was aware. However, if you look at the facts of the case, they are very similar in terms of the way in which they were detained and how they were processed and so on. What was interesting in this case, however, was that they weren't deemed to be vulnerable. Why were they not vulnerable? They weren't vulnerable because they're not asylum seekers, or as I much more prefer to phrase it, they didn't, during the time that they were in Europe, actually seek asylum or have the opportunity to do so. So while MSS has been seen as a case in which it's great from asylum advocates that now we're recognising the vulnerability of asylum seekers, and that was a controversial decision by the European Court politically. What we also see worryingly is this move to almost reinforcing this heavily criticised categorical approach of vulnerability. That we're saying that people are vulnerable because of asylum seekers, but what the court's essentially then doing is if someone is not an asylum seeker, they are not vulnerable. So rather than the hope from MSS and the literature around that, the hope was vulnerability would be used to provide greater protection for those travelling across the Mediterranean, recognising the fact that they are in a situational sense they're vulnerable because they are travelling across the Mediterranean in very precarious situations. Rather than seeing that, we're instead seeing this exclusionary use of the term vulnerable once again, where anyone who is not an asylum seeker, or anyone who is not a woman, or anyone who is not a child, will be found immediately invulnerable, and therefore they do not deserve any heightened level of protection from the European Court, despite the fact that they themselves have been through a very similar situation. So, my thoughts on this? Well, my thoughts are that the court has had this opportunity. It's had an opportunity to think about vulnerability in the context of the Mediterranean migration crisis in a far more sophisticated manner. It's quite clear, actually, if we look closely at the cases, that the court does recognise the fact that those crossing the Mediterranean are in a situational source of vulnerability. They are affected by the situation they're in. And that equally they recognise the fact that children are more vulnerable. So they sort of use this inherent and this situational. The issue is, though, even though the court is recognising the inherent and the situational sources of vulnerability, they're applying this in a heavily categorical manner still. The outcome of that being that we see greater exclusion of those, we see inclusion of asylum seekers, but we see greater exclusion of those who are even more at the margins of society, those who are undocumented migrants crossing over to Europe. I pose this sort of question at the end, which is this a sign of the times? Is it showing that the European Court is behind the times? I think it's probably both. There are some interesting angles to explore here about, we have to remember that the European Court is a political being, and to what element the European Court is actually taking heed of the political environment within Europe right now, and perhaps stepping away from its human rights basis. That's just a speculation, I won't go any further than that. But there is also something to say, thinking back to the bioethics literature. In many of the regulatory frameworks and the relevant frameworks in bioethics, we see this very concrete move now away from a categorical approach of vulnerability, that we should assess people on an individual basis. My argument is that we're seeing the opposite happening in law. We are seeing greater reliance on the categorical understandings of vulnerability leading to further exclusion. And that's sort of what I'm moving into now, essentially looking much more concretely at how vulnerability is identified at the point at which people arrive into Europe, and from me, for a legal perspective, looking at what the requirements are in law as to what states should be doing to recognise vulnerability. And my fear is that the requirements are being lessened and lessened, when in fact we probably want the opposite to be happening. That's me.